Today, on this episode of The Crossover, we will be discussing medical malpractice, what all doctors need to know, with nationally recognized medical legal expert and partner at Hinshaw and Culbertson Law Firm, Diane Webster. Learn about the litigious healthcare environment in the United States and what doctors can do to best protect themselves from lawsuits. Much more on this episode of The Crossover. Good afternoon, everyone. We're going to be talking with Diane Webster today about medical malpractice and what every doctor needs to know.
Hi, Dr. Komatar. Can you hear me?
Yeah. Hey, Diane. How you doing?
Good. How are you doing?
That's a hell of a view you have in the background there.
Thank you. I got lucky with a nice weather day here in Chicago, so.
Oh, that is awesome. All right.
Thanks.
Well, listen, just while everyone logs on, I'm going to do a brief introduction. We have the pleasure of speaking with Diane Webster today, who's a medical legal expert and senior law partner. She's a trial attorney who specializes in healthcare litigation, products liability, pharmaceutical liability, and surgical device litigation. Her clients include hospitals and physicians, insurance companies, medical and surgical device companies, state and county governments, a Major League Baseball organization, several corporations and school districts as well. She defends multi-million-dollar complex catastrophic litigation cases involving medical negligence, birth trauma, obstetrics, neonatal negligence, neurological injuries, and alleged defective or malfunctioning surgical devices. I won't get into her honors and awards because they're too numerous to mention, but needless to say, she's a leader in her field. And we are here today to discuss medical malpractice, what every doctor needs to know. So thank you so much for joining us, Diane.
Thank you so much for having me. It's truly an honor. I'm really excited to chat with you this morning.
Well, let's just start out with a little background. You know, how little do most doctors, in your experience, understand about medical malpractice?
I think it's surprising that they really don't know very much, despite being experts in their field in terms of, healthcare and, practicing and just being wonderful. It's a totally different world in terms of what goes on the legal side. And so I think a lot of us, in terms of what I do is spent kind of educating and trying to, help explain the process. I mean, in terms of medical malpractice, generally speaking, it occurs when a healthcare provider fails to provide appropriate treatment, fails to take appropriate action, or gives, substandard treatment that leads to harm, injury, or death to a patient. And, I can tell you a little bit in terms of the numbers, but there's approximately 20,000 medical malpractice lawsuits filed each year in this country. So it's sizable. And, this isn't trying to scare anybody, but sometimes it kind of does. In terms of how common the suits are, 1 in 3 physicians will be sued overall, and by the age of 55, 1 in 2 will have been sued. So it's just something that I think, you need
to. I can't hear you. I think you lost sound. Are you back? Yep. Yeah, there you go. Now you're back on. So what was that last part you said? Just because I missed like maybe 20 seconds of.
Oh, so basically I was just saying that hopefully after we finish up our discussion today, we can kind of, inform your viewers a little bit more about this sort of high level, and then we can kind of dive in a little bit.
Based off those numbers that you said, 1 in 3 physicians getting sued by the age of 50, 1 in 2. Do you think that there should be formal legal education in medical school?
Yeah, that's a really good question. I kind of think that, we should. I think that there's, as I understand it, as physicians, many of you participate in sort of like RCA or root cause analysis or quality control or peer review type meetings. I think, that something like that, like a class or a series sort of, along those lines in school would really be helpful in an effort to kind of more litigation proof your practice. You can be absolutely perfect and wonderful and just the best at what you do, and you can't always prevent the suits. And, we can talk a little bit more about that later, but I certainly think that, some type of, education about this process can go a long way in terms of some of the things that you probably know. Documentation is key. Relying less on, forms and templates. I'll give you an example. Oftentimes when I first started practicing, we still had handwritten charts. Now everything is electronic. So, you could go in there and, for example, a patient will come in and say, my leg's really bothering me. I've got this, this calf pain. And so that's what their chief complaint is. And then you'll go through those templates that you get as you're kind of assessing them. And for example, in a review of systems, it'll say, okay, you're examining the skin and you're examining, the GI and everything else. And then you eventually get to, the lower extremities, and a healthcare provider will put negative or normal, and yet they came in with a chief complaint of calf pain. So they're inconsistent, and it looks bad because later on, if there's a suit, then, we have this inconsistency, and it either is you didn't really do a good job evaluating them, or you kind of went through it, or maybe you skipped it altogether. So it's those types of things that you really want to pay attention to in terms of documentation. Other than that, there's all sorts of things you can do in terms of making sure you include other people's involvement, conversations with consultants, things of that nature. But yeah, I do think that some type of, formal education or a series where you talk about different topics in school will be really, really helpful and go a long way in, preventing suits.
What have you seen are the highest risk areas of medicine for lawsuits?
So it varies, but generally the ones that you see the most are anesthesiology, surgery, including neurosurgery, plastic surgery, general surgeons, orthopedists, and urologists. And the one that I also want to include in there, although statistically it wasn't in the top 5 for many of the studies I looked at, but in my experience is OBGYN. And it's not so much the GYN part, but the OB part. And that stems from, as you can probably imagine, birth injury cases, which are, the most serious, of the ones that we have to defend. And that's in large part due to the fact that the damages are extremely high on those types of cases. As you can imagine, they're obviously, number one, extremely sympathetic on both sides. Everyone, acknowledges that these are difficult cases and feel, terrible about it. But the other issue is just that these children are oftentimes going to need a multitude of services all the way, into adulthood and for the rest of their lives. And you can imagine they're extremely costly.
Now, I think one of the biggest things about the legal system we have is that it essentially forces many doctors to practice some defensive medicine. And I think that's a big complaint when you talk to physicians who have been practicing for 40 or 50 years, the way they used to practice in the 80s, 90s, 2000 versus now, it's not taking care of the patient. It's how to avoid lawsuits, which is crazy. If you think about it, that's no way to practice medicine. What are your thoughts on defensive medicine and how we can fix that?
Yeah, I mean, that's exactly right. I mean, and I've seen it even in my own practice over about 20 years. I mean, there's, definitely an increase in, the likelihood of someone having a particular condition could be 1% to 2%, but that physician is going to order that extra MRI just to be sure, and it's really expensive. I suppose, I think that goes back to the documentation in terms of, if you really don't think it's necessary, you can say, the likelihood is not there. However, explain to patient there is this possibility. Feel comfortable and patient agrees to, not move forward with particular test despite, full explanation of, the risks and benefits. And it's kind of all of that. But, you're exactly right. I mean, that's what people are doing. And, they're ordering a bunch of tests, and certainly, tests, images, bringing in consultants that may not really be needed. But, that's something that I always try to defend against as well, in these types of cases, because that oftentimes is what they say is, well, it would have been safer for you to have ordered this, or, it doesn't cost much to just do an extra, an x-ray or something like that, or to just order this pill. And it always goes back to, well, what's the standard of care? Because that's the standard that matters. And that's the standard by which physicians and other healthcare providers are judged. So, and since we're talking about this, the standard of care is, it's a reasonableness standard. It's not a perfection standard. And so what it comes down to is, generally speaking, and it varies, by jurisdiction, but it's, the standard of care was what a reasonably careful, reasonably well-qualified physician or healthcare provider would do in the same or similar circumstances. And that's it. So, it ties into some other topics that, we may get into today, but, plaintiffs' attorneys are oftentimes trying to increase that standard to an improper one that's not what the law actually is. So, that's kind of what it goes down to. And ultimately, if you were acting within that standard in terms of what your peers would be doing and what is accepted, then you're going to be fine, despite whatever claims they're making.
Now, people tend to think that, lawsuits happen immediately after an injury or some kind of unfavorable outcome. That's clearly not the case. What is the typical time course for a lawsuit after the incident, and how long do these drag on for, in your opinion, or in your experience?
So maybe a little bit more bad news. So there is a statute of limitation on these. It varies again, in terms of your jurisdiction and what exactly the alleged, malpractice is. For example, there's a longer statute of limitation for something like involving the discovery rule. You have a sponge, you left it inside, you may have passed the statute, but it only caused problems for the patient a couple of years later, perhaps after, the statute is expired, but there's exceptions for that. Likewise, with minor patients, the statute is longer. It's told because, they are, minor children at the time that, the incident potentially occurred. So putting that aside, assuming that it's filed within the, on average, 2-year time frame, and again, depending on your jurisdiction, where I am here in Cook County in Chicago, Illinois, it's not uncommon for a case to go in excess of 2 years from start to finish, and oftentimes much longer. I've had cases go 8 years. So, so that also kind of, goes back to, healthcare providers need to have an honest conversation with their lawyer, which hopefully they have a good relationship with, or find one and get a good relationship with them and talk to them about how often you want to be, you want them to communicate with you. I have clients that'll say, I pay you to do the worrying for me. I don't want to hear anything except for real key issues, give me a call. Otherwise, let me know when I got to show up for trial or whatever. And I have others that are like, nope, I want regular updates on what's going on. But it can take a few years. And the reason why is, dockets are crowded, but also, once the plaintiff files the complaint, that kind of kicks off the action. So from that point, you have, the option of either answering it, okay, and you most of the time will be denying the allegations, and or filing some type of a motion to get yourself out. Assuming there's no basis to get out on a motion and the case starts going, we exchange these written documents. We call them written discovery. They're typically things like interrogatories and requests for production. These documents sort of form the basis for what's going to take place and kind of give both sides information before you start the depositions. The plaintiff typically goes first. The defendant oftentimes will go after, and then there could be a series of fact witnesses, family members, perhaps other treating physicians that maybe saw this person that are going to weigh in. Once all of the fact discovery is closed, you get into something called expert discovery. And with medical malpractice cases, I'm a lawyer, I'm not a healthcare provider, I don't have medical training. Just like most of the time the plaintiff's attorney, we don't get to say, oh, I don't like the way, Dr. So-and-so acted, we're going to bring an action. You need to have some type of medical expert to sign off in the first place and say it's valid, that there is a basis to do it. And then later on, you need experts on both sides to say, well, what's the standard of care? And, plaintiff is going to say they deviated from it. And the defense lawyer is going to have an expert that says, no, they adhered to the standard of care. They explain the reasons. And it's only at the conclusion of that the case is ready to go to trial. And so, and then of course, that is in and of itself can take several weeks depending on how complicated the case is and the number of witnesses and experts. So we're looking at a little bit of a timely process.
Now, along those same lines, I think everyone knows that the healthcare costs in the U.S. are more than any other country on the planet. And a big part of that are the frivolous lawsuits. How do we control frivolous lawsuits in this country, which are just out of control?
So, again, it's a little bit of a tough answer. There's most of the time there's not much you can do in terms of preventing them from filing suit. They don't contact you the majority of the time before they do it. They just file it, and then you unfortunately get served and you're like, wow, there's a suit, great. The only time that you can really prevent that is if once in a while you'll get a call from a plaintiff's attorney, who is saying, this is what I'm planning on doing. And, you can try to, if you have a relationship with them, or if the case truly is frivolous, you can tell them you're wasting your time here and have an honest conversation about it. That's, more often than not going to go anywhere, and they're still going to do it, but you never know. I've had some success here and there, but generally you don't find out until after it's sued. So at that point, really the only option you have is to get a good defense lawyer that's going to be aggressive and, working up the case with an eye towards early dismissal by motion practice, retention of really, really good experts, and, putting on a very strong defendant deposition early on to the point where, they're going to recognize pretty quick that they're wasting their time. And these cases are very expensive to file on the plaintiff side because unlike regular personal injury actions, you got to have experts, and experts are expensive. You have to pay them for their time, for their review. If they're flying in to do depositions, flying in for trials, it can be very, very expensive. So those are, some of the ways that you can try to reduce them. It's just really hard to prevent them from filing them in the first place.
Now, let me ask you about two different measures that people have taken to avoid frivolous lawsuits. One, Texas, who limits the amount that you can get for these medical malpractice suits. I believe it's $250,000, $250,000. What about that thought for limiting, lawsuits that are just completely frivolous and asking for several millions of dollars?
Yeah, that's a great point. And, you're right. It does depend where you live. In Illinois, there's been attempts to do tort reform. It's been ruled unconstitutional, and there are no limits here in the state of Illinois and in other states. States like you said, Texas, which, I was unaware of, but Indiana is another state where they do have caps. And so, certainly, those, a lot of physicians will lament and say, hey, I'm getting out of here. I'm moving to one of those states. But yeah, it kind of does depend on where you live. I think I did have a stat over here in terms of, well, does it matter? And it kind of does, because the majority of the suits, if I recall, naturally their higher population areas are Florida, California, Texas, New York. So it does matter.
And let me ask you a question. What do you think about the option that I believe they do in England, which is if you file a lawsuit and you lose, that you got to pay for all the legal fees? Wouldn't that reduce frivolous lawsuits?
I'm sure it would. I don't see that happening in this country, but yes, I agree with you. They also, I think from some of my UK friends, think that our system is very, very fascinating to them, because we may be the only, certainly a few countries where your fate is decided by, just not your peers, but just, regular people in the community. Whereas over there, they have, a panel of experts that are making the decisions. But it is fascinating. And, I will say that the majority of the time, they really do get it right in this country. And we oftentimes, even when I'm having jury trials, we have observers from other countries, watching these, because they just, think it's fascinating that we'll have, someone with absolutely no medical training. And most of the time, you will have a jury with zero medical training or background, and they're hearing it for the first time. And it's our job, together with the witnesses and our experts and our clients, to educate them and to hopefully come to the right decision.
So let's get into what every doctor needs to know about malpractice, right? First of all, what are the two main types of medical malpractice insurance?
Okay, so there's two types. There's claims-based and there's occurrence-based. So with claims-based, it's the policy only covers incidents that happen and are reported within that policy's time frame, unless something, it's called a tail, is purchased, and the tail will cover you for a designated period of time after that policy time frame. And then occurrence-based is basically, it's a lifetime coverage for the incidents that occurred during a policy period, regardless of when the claim is reported. I'm not an expert in insurance, but my understanding is that claims-based policies are initially significantly less expensive than occurrence-based policies.
Which one do you recommend getting? I mean, is it in your opinion better to spend the extra money?
I mean,
or is that
by nature of the work that I do, I'm risk averse. So I'm always like, get as much coverage as you can, get as much tail as you can, just to, I'm a worrier, and basically they pay me to worry for them. So that's what I would say. But yeah, that's where it helps to have a good broker that you talk to in terms of explain to you, what the various options are, how much they cost. And I mean, that's a whole separate conversation that you could take it over an hour and have a podcast just about that.
Yeah, and it probably also matters what your specialty is, right? If you're doing something like OB-GYN or anesthesia, like you said, that are super high risk, you want maximal coverage. So I guess it's going to be different for every single physician.
That's right.
But what is a consent to settle clause, and why is that important to know for the physician?
Okay. So a consent to settle clause generally requires that an insurer obtain the insured's consent before settling a claim, where the insured's consent, can't be unreasonably withheld. So basically, and not all insurance policies have this, but many do. So it's important to understand. The reason why it's important is because once you consent to settle, most of the time, and again, this is something you want to review your policy and discuss with them. But most of the time, once you say, yep, I want this to go away, I don't want to deal with this anymore, at that point, you don't really have any control over what the amount is or how much it's settled for. So it could be $1 or it could be the total amount of your policy limit, and obviously there are implications associated with that if it is a policy limit, tender. But that's typically how it works, is you say it's over, try to make it go away, and then they do, but you can't kind of say up to $20,000 or up to this amount. It doesn't work like that most of the time.
But, people might ask, what are the downsides of settling, right? I mean, isn't this stuff made public? You're basically seen as being guilty regardless of what was done. So what is the downside of settling?
Well, typically when we enter into settlement agreements, the standard language is theirs is not to be viewed as an admission of fault, but simply, in other words, a business decision. So that language is pretty much in every single agreement. But you're right. With that being said, there is a potential impact on your premiums going forward. There is, you have to report it on your future credentialing and recredentialing. It's going to come up. Usually you can work with your lawyer in terms of, helping with the language when you do that. And then you have to report it to the National Practitioner Data Bank. So yeah, there is going to be a record of it. And so for that reason, many, healthcare providers don't want to settle. Physicians don't want to settle. That's why I have the trial experience that I do, because most of my clients, would like to proceed forward to verdict and feel very strongly about the care and treatment that they rendered.
How easy is it for patients to find out legal history of their physicians? How many times they've been sued? How many times they've settled, lost, won, all the above?
There's definitely ways to do it. I mean, for me, it's very easy. I know exactly which, websites and, databases to go to, but there are public dockets, in most jurisdictions, and you can put in a physician's name and you can search and you can see their litigation history, and it'll usually list, all of the suits that they've had. So it's pretty easy. If you look in the county that they're working in, you can see, because it's all public.
Do you know if hospitals use this as background when they're hiring people?
That's a good question. I don't know if they check websites or anything like that. You would have to, ask someone there, but I'm sure that, in terms of your credentialing, you have to tell them what your litigation history is, and they're going to know the number of suits, usually what the disposition is, were you dismissed, did you settle, did it go to verdict, did you win, all the details. And if you didn't, what was the verdict, what was the judgment, so I think they do know all of that history, and that's probably part of your credentialing.
Do you know how many lawsuits eventually lead to losing your license? Is that something that you're involved with? I guess different boards have different criteria, but have you seen that up in Chicago?
I don't know the numbers, but what I can tell you is, the part that I'm involved with, which is the pending litigation, we have to get to some type of a resolution. And then, if you lose, then, there's a judgment you have to pay. Whether or not there's a subsequent disciplinary action stemming from that, separate, apart, or whatever, that's a totally different issue in terms of how, if your license is going to be disciplined or, I don't know, revoked in some way. That's a totally separate thing.
How would you compare our U.S. medical legal system versus other countries? Like, for what do you feel like we are advanced, that we have a good system compared to other countries, or do you feel like, for many reasons that we brought up before, that it's a little bit frivolous and anyone can sue anyone for any reason and it just ends up mounting?
Yeah, I mean, as being born and raised in this country and only practicing in this country, initially getting involved with it, it does seem crazy. You have, potentially a psychiatrist sitting on your jury. You may have an accountant sitting on your jury. You may have a garbage man. You may have, someone who's just not working at all, a retiree. I mean, you get the whole mix. And, intentionally, most sides, both plaintiff and defense, don't want any doctors sitting on the jury in medical malpractice action for various reasons. You want kind of a clean slate, and then you have the opportunity to, present evidence, cross-examine, and, it's an opportunity to kind of educate them about the facts of the case. And through, like I said, your client, the experts, you kind of explain what it is. And you'd be surprised at how interactive they are, how much they pay attention. They're taking notes, and they really value the process. Initially they look like they want to die. When they get impaneled, they find out that they're not going home. So, but when you finish and you get to the end, they're very excited to tell you how they came to the results, how much they learned from it. They thought it was an invaluable experience. So I do think that it works. They, through the system and through, various, measures during the trial, through cross-examination and everything, I do think that we get to the right result majority of the time. In
your opinion, what is the number one improvement that we can make for the U.S. medical legal system?
That's a hard one. Number one improvement?
Yeah, things that every day you see and you're like, wow, I wish we could fix that. There's these issues with the system.
Yeah, I mean, it kind of, I guess it goes towards just but it's probably, consistent with what we're seeing in society today is these nuclear verdicts are, I think, probably the number one thing. When I started, what would typically, we have an idea based on, verdicts and settlements in terms of how to value these cases and, what they're really worth. And, what could have been a bad injury that'd be worth 5 to 10 million when I first started is now, 50 million plus. So it's sort of a trend that we're seeing, and I don't think it's going away. While the filings, I would say, have gone down slightly, they're not as prevalent. The settlements and the verdicts have gone way up. So in part, I think they've gone down just because they're expensive to defend or expensive to prosecute on the plaintiff side. You have to get the experts, which are very expensive. And there's other ways of, other actions, other practice areas that they can focus on that are not quite as costly. But like I said, with everything else in society, oh my God, the settlements and the verdicts have gone way up. So if they could, and it's really, when you look at the numbers and if you were to parse it out and see, well, what is it really going to cost to take care of this person? Hypothetically, if in fact they feel that there really was negligence, what is it going to cost to support this person, make sure that, justice has been served? They, oftentimes way exceed this number that, what I mean? It goes leaps and bounds above what it really should be. That's kind of, what we'd like to see. And in certain jurisdictions, it's not even, it's the norm these days. I think that that's probably true where I practice as well.
So you use the term nuclear verdict. I don't think many people are kind of familiar with that term. What is a nuclear verdict and what does it mean?
Yeah, it's basically just kind of what I was describing, whereas, these are numbers that, most people would be like, wow, that's an insane amount of money. And it goes way over what the actual damage is, support, but, for various reasons. And, that's another trend that I can get into now, that the reptile tactics are contributing to that. And so reptile tactics or reptile theory is something that it's a theory that was formulated, I think, like in the 1950s, and then some attorneys wrote a book about it probably 15 years ago, if I'm not mistaken, and it since has really taken off. When I first started practicing, I almost never saw it, and now I see it in every single case, and I see it in trials, and it's really important that defense attorneys are good and understand, they recognize them, and they get aggressive and treat these up front. It's totally improper. It's basically, they call it the reptile theory because it attempts to kind of tap into or trigger the reptile theory or the reptile part of your brain to make you feel afraid and to cause you to take action. And it, instead of the reasonableness standard that I talked to you about early on, this is sort of an attempt to kind of trigger that fear and, say, well, the questions they'll say is not, is it the standard of care based on a reasonableness standard, but what's the most safe? Was it the safest thing for them to do that? And that's not how medicine is practiced. It's improper. And defense attorneys need to be aggressive, and they need to prep their clients to be aware of these when the questions come in during depositions about what is safest. They're improper, and what it is an end-run attempt to misrepresent the standard of care, which is totally unethical and inappropriate. So it's that reptile theory that is causing jurors to be afraid and to wanting to send a message or punish, defendants in various situations, hospitals, healthcare providers. And I think that, coupled with social inflation, everything else we're seeing is taking it through the roof. So that's kind of the biggest problem and a trend that I'm seeing, and I don't think it's going away anytime soon.
Yeah, I mean, it's scary, the kind of picture you're painting, and I could talk to you forever, but we got to wrap it up.
Mm-hmm.
I feel like in this country, anyone can sue anyone at any time for doing anything, and that's ludicrous. And the trend is more lawsuits, higher settlements, and the theory is, people get a lawsuit and they just assume the doctor did something wrong. So even doctors that are fantastic at their job and did nothing wrong can still be sued. And I feel like those frivolous lawsuits need to somehow be controlled. I'm not sure how we're going to do it, but it's a major problem. And like you said, most doctors have no idea about, malpractice. I certainly do not know much about it. And I feel like there needs to be some type of formal education in medical school because it's so common. And it doesn't mean you did something wrong to get sued. You have to know how to defend yourself. So again, thank you so much for your time, Diane. I don't know if you have any closing thoughts or ideas.
No, I mean, it's been a pleasure speaking with you this morning. And, if you want to go into any of these other topics another time, I'm here.
Awesome. It's a great topic, and I'm glad we have people like you defending us.
Thank you. Thank you so much. Truly a pleasure.
Awesome, Diane. Have a great day.
You too. Thank you.
Take care.